Hi, I am Saul Lee from Saul Lee Law Firm. Today, I would like to introduce you to copyright. Copyright is one of the intellectual property that a lot of people probably heard of, but people are really not sure what copyrights are. So when we talk about copyright, the definition of copyright under the statutes are as follows. To be eligible for copyright protection in the United States, the work must be, number one, be fixed on a tangible medium. Number two, be created by human author, not a mere mechanical process without any creative input or intervention from a human author. Number three, contain a minimum amount of creative authorship, that is, work is original to author and has a modicum of creativity. And finally, number four, the work has to fall within one of the categories of copyrightable subject matter. It's really hard to understand this. So to break it down, you have to understand that it has to be fixed on a tangible medium. What that means is it has to have something in between what I see or what I hear or what I feel. But what that means is pictures, videos, music. There has to be a tangible medium in between where you can feel the expression of idea. And it has to be created by human author. What that means is it cannot be a mechanical process done by AI or a machine, but it has to be done by a human. And number three, the work has to be creative and original. And lastly, it has to fall into a category. So what falls into this copyright categories? Literacy work, musical work, dramatic work, theater, pantomimes, choreographic works, picture, graphic, sculpture work, motion picture, other audio-visual work, including, let's not forget, software and games. All of these fall into copyright protectable work. When we say it like that, it sounds big, but a lot of things we deal with on a daily basis is art. We can consider that as copyrightable work. Then what is not eligible for copyright? Work that is not eligible copyright protection is if it's just an idea. Let me give you, if it's just an idea, then it's not really copyrightable work. So what do we mean by this? When we talk about this, my common example that I give it to people is a Cinderella. The story of Cinderella is copyrightable work because we have specific character named Cinderella. We have specific stepmother. We have specific stepsisters who harass Cinderella. And the Cinderella, lives a certain lives, meet a specific prince, and then get married to him. This storyline with the character in it is an original work because it has an original name. It has creativity in it. However, if we simply take out the idea and say a poor girl who was really nice, suffered through, met a really rich man, and got married. This idea is not copyrightable because this is just an idea. These are very common themes that doesn't really have originalism to it, that is not really copyrightable. But this is how you distinguish the two, what is original, what can be considered as a copyrightable work, and what is just mere idea. The other thing that we also commonly say is not copyrightable is functional object, system, algorithm. If we're talking about really putting in some calculation, software system that is using some calculation of natural algorithm, that's really not copyrightable. A function that is not aesthetic, if we're talking about a particular design that has function that creates certain design that doesn't have aesthetic feature to it, that cannot be copyrightable. What right a copyright holder will have? Copyright holder has an exclusive right to reproduce the copyrightable work in copies or phonorecords, and also has a right to create a derivative works based on the copyrighted work, and also distribute these copies of the copyrighted work. How long is this copyright? Copyright is a lifetime, is protected for the duration of author's lifetime plus 70 more years. Okay, when do I have to register copyright by? So you can register your copyright at any time, but typically our recommendation is 3 months from the date of your copyright is created. And what that means is when your work is done, when your work is completed, we strongly recommend you to register within 3 months. The reason is because if you do register your work as a copyright within 3 months, you are qualified for what is called a statutory damages. These statutory damages are a minimum of $750 goes to $3,000 per item. Why is this important? If you remember the copyright infringement, a lot of these copyright infringements comes from a very cheap reproduction. You will see these fake movies you download illegally on a website, and these things a lot of times are free or very minimal value. They're $1, $2. So when we talk about damages, you're really talking about a very small amount of money. What the statutory damages is increasing number dramatically. All of a sudden, per item, the infringers are responsible for $750 per item, up to $3,000 per item, which all of a sudden raises your damages and really becomes powerful. And that is only possible if your copyright is registered within 3 months from the date of completion. So let's make sure that we register your mark within 3 months to get this protection of statutory damages.